Hello everyone and welcome to this Beale & Company webinar on interim measures in international arbitration. I'm Nadir Hassan, an associate at Beale & Co.'s London office, and I'm joined by Sadaff Habib, an associate at our Dubai office. We're hosting today's webinar live from the International Arbitration Centre, an exclusive hearing space in the heart of legal London offering 5-star purpose-built ADR facilities. I'd like to thank Owen Lawrence and his team here for making us so welcome and enabling us to present from this fantastic hearing space. We anticipate that today's webinar will last for about an hour. Please do submit your questions throughout the webinar as soon as you think of them. You'll see instructions on the screen in front of you showing you how to do so. We'll then circulate answers following the webinar. We'll cover 4 main topics today. First, when to seek interim relief during a dispute and the factors to consider in doing so. Second, whether to go for courts or emergency arbitrators when seeking interim relief. Third, obtaining interim relief during arbitration. And finally, enforcement of such interim measures as you may obtain. We'll look at interim measures from both a common law and a civil law perspective, drawing on my and Sadaff's experience in London and Dubai respectively. We'll also try and provide as many practical examples throughout the webinar as possible so as to link what we're saying to real-world applications. In the first section of this webinar, we'll look at, in basic terms, what interim measures are, why and when you might want to obtain them, and the factors you need to bear in mind when doing so. The first question then is, what actually is an interim measure? An interim measure in the context of a dispute process, whether arbitration or litigation, is generally considered to be an order granted by a judge or arbitral tribunal, and that includes an emergency arbitrator, before or during the course of formal proceedings, and we'll come on to look at when and why you might want an interim measure before proceedings commence, against a party to those proceedings or against a third party, and again we'll look at why you might want to bring in a third party, requiring that party to do or refrain from doing something, usually on a temporary basis. Typically the order will be effective until the final award of judgment, or at the very least until a subsequent order in the same proceedings, and possibly without notice to the other party. This is a crucial issue and one that again we'll come on to discuss. The next question is, when might you want an interim measure? There is of course an incredibly broad range of circumstances when you might seek an interim measure, and there's an equally broad range of interim measures that you could apply for. Just a few typical examples are as follows. If you're the claimant, you may be worried that the defendant to proceedings or prospective proceedings might dissipate its assets and place them beyond the reach of the court or tribunal. In this case, you'd most likely want to apply for a freezing order. If you're the defendant, you may be concerned that the claimant will not be able to pay your costs of defending the proceedings if you win. In other words, that you might be left out of pocket for no fault of your own. If this is the case, you might apply for security for costs. The other party may commence proceedings in another forum, and you may want the arbitration agreement respected. In this case, you could apply for an anti-suit injunction. You may be worried that the other party, or even a third party, might destroy evidence crucial to the claim, or property that is a subject of the claim. If this is the case, you might seek an order for delivery up or a search order. More generally, you may have any good reason to want the other party, or sometimes the third party, to be ordered to do something or to not do something, and you may apply for a mandatory or prohibitory injunction accordingly. And we'll explore 3 specific examples of when you might want an interim measure in a little more detail in the next few slides. Possibly the archetypal example of an interim measure is a freezing order, which some of you may have known back in the mists of time as a Mariva injunction. A typical circumstance when you might want a freezing order is when you're the claimant and you're in the process of bringing arbitral proceedings against someone with mobile assets, say a wealthy businessman, say. You're at the pre-action stage of proceedings, perhaps there's a tiered dispute resolution provision in the contract and you can't yet file your RFA. But your prospective defendant starts moving his assets, cash in his bank account, stock in trade, his planes and yachts out of the jurisdiction, and into one where you know enforcement is notoriously tricky. You want these assets preserved and kept within the reach of the courts, so that once you obtain an award in the proceedings, assuming that it goes your way, you can enforce it against them. To do so, you could apply for a freezing order, which is in effect an order restraining the prospective defendant from disposing of or dealing with its assets. As in this example you've not yet filed the RFA, there's no tribunal in place, so you could go to the courts or you could seek the appointment of an emergency arbitrator, if permitted by the agreement and the rules governing the conduct of the arbitration. Another example, international arbitrations typically involve parties from multiple jurisdictions. Parties often think they may be able to get a home court advantage, for example, if the dispute is tried in their local courts. Irrespective of the existence of the arbitration agreement, therefore, a party may commence proceedings in a local court or arbitration institution. To prevent this gambit from succeeding, the other party could apply for an anti-suit injunction. A typical circumstance in which an anti-suit injunction could be relevant is when you're the claimant and you're bringing arbitral proceedings against a foreign entity, a company from another jurisdiction, say, or a foreign government. Once you file the request for arbitration, the defendant could try and delay the progress of the arbitration. For example, it could repeatedly challenge arbitrators you nominate, it could refuse to cooperate in the process, it could delay constitution of the tribunal, and while it does so, it could commence proceedings in its legal courts. Now, what you want is the arbitration agreement to be respected, so the dispute is heard solely by the tribunal and not by the respondent's local courts, and to do so you could apply for an anti-suit injunction, which is in effect an order requiring the defendant to discontinue the court proceedings and restraining it from commencing any further proceedings until the tribunal's issued the award. In this example, the tribunal's not yet been constituted, so you could go to the courts, you could seek the appointment of an emergency arbitrator, again, if this is permitted, or you could simply wait for the tribunal to be constituted and seek an injunction from them. There are, of course, practical queries, such as whether the local courts will respect an anti-suit injunction. That, I'm afraid, is a whole other talk altogether. And the last of the in-depth examples addresses witness summons. Typically, this is an issue that would arise when arbitral proceedings are underway. You're approaching the witness evidence stage of the proceedings, you identify a witness within the jurisdiction who can give crucial evidence, and you want the witness to be compelled to appear before the tribunal. As proceedings are underway, the tribunal has been constituted, unlike in the previous two examples, so you'd think you could simply go to the tribunal and apply for an order compelling the witness to appear and give evidence. But as it turns out, this is an exception to the general rule. At least in England, you must apply to the court for a witness summons. We'll consider this in more detail later. There's a common thread running through all of the above examples. The first commonality, and the most crucial one from the point of view of these being interim measures, is that you need relief promptly. You can't wait for the substantive arbitration to conclude and for the final order to be issued. By that time, the defendant's assets may have been dissipated, the local court may have handed down judgment, and the other party may have started enforcing it, and it will be far too late for witness evidence. Secondly, you need an order that is enforceable. It's all very well having a piece of paper from, say, an emergency arbitrator, but if the order written on that piece of paper isn't going to be given effect to, for example, if the local courts don't recognise the authority of the emergency arbitrator that issued it, then has the entire interim application been a waste of time? Thirdly, in the above examples, the tribunal may not have been able to act. In the first example, the arbitration hadn't commenced, so there was no tribunal to consider your application. In the second, the RFA had been issued, but the tribunal still hadn't been constituted. And in the third, although the arbitration was well underway, the tribunal simply didn't have the power to grant the order that you sought. Now, having looked at a few different situations with different priorities and obstacles, in broad terms, the main considerations we've come up with as regards deciding whether, when and how to seek interim measures are the following. First, can you get the remedy you want? Is it within the gift of the tribunal or the emergency arbitrator or the court to grant it? Second, will you get the remedy you want? It may be possible for the order to be made, but is the remedy you're seeking so drastic that the court or tribunal will be reluctant to grant it? Third, how long will it take to obtain the order? Can you simply go straight to court with an application, or do you have to first seek to have an emergency arbitrator appointed and then apply to that arbitrator? Fourth, how will you enforce the order that you're granted? Is the order directly enforceable once made? Does there have to be a further breach before penalties kick in? Or do you have to then commence further proceedings to enforce it? And allied to that, what are the penalties for breach? Fifth, do you have to give notice to the other side of your application for the order? For some applications, for example freezing orders or search orders, a requirement to give notice could be disastrous, as it could lead to the respondent accelerating its dissipation of its assets or the destruction of its evidence in anticipation of the order being granted. Sixth, are the proceedings confidential? A well-known advantage of arbitration over litigation is that proceedings can be completely confidential, and in fact, if you'll permit me a minor plug, I have an article on this coming out in the next few weeks. If the matters in question are particularly sensitive, this could be an important consideration. So, bearing these priorities in mind, what are your options for obtaining interim measures? First, you could apply to the courts. These could be the courts in the jurisdiction where the arbitration is seated, the jurisdiction where the respondent to the application is located, or the jurisdiction where any relevant assets or indeed evidence are located. Which courts are best to apply to will depend on a whole host of factors, and again, an analysis of the considerations affecting this is a whole separate talk. One of the key questions when applying to court is considering whether the court has jurisdiction. If there's a valid arbitration agreement in place, courts will often be reluctant to step in and assume jurisdiction, and if the application is with notice, you risk the prospect of a jurisdictional objection on an interim application. Sadaff and I will consider this issue in a bit more detail later in this webinar in relation to both common law and civil law systems, but I will note here that the stage at which the arbitral proceedings have reached is relevant. If the tribunal's not been constituted as yet, the courts may be more willing to assume jurisdiction than if there is a competent and functioning tribunal in place. Another key question is whether the courts you're applying to can grant the remedy you seek. For example, English courts will not summons a witness outside the jurisdiction, so if your witness is in Dubai, don't bother. Court orders, however, probably have the most bite. We'll look at enforcement in greater detail towards the end of this webinar, but I'll say for now that an order given in the name of the state is a powerful weapon to have in your arsenal. Court orders can bind third parties, which arbitral tribunals in most cases simply can't, and a failure by the respondent to comply can in and of itself constitute contempt of court, which can have severe penalties. Your second option is to apply for the arbitral tribunal, assuming, of course, that you can do so. Clearly, you can only apply once a tribunal's been constituted. If it hasn't, though, can you wait for it to be constituted, or is it wiser to apply for the courts or seek appointment of an emergency arbitrator? Applications for interim measures can, by their very nature, be very time-sensitive. On a similar note, does the arbitration agreement permit the tribunal to grant the relief you seek, or any interim relief at all? If it's silent, do the rules of the appointed arbitral institution say anything? How about the arbitration laws of the place where the arbitration is seated? Sadaff and I will run through this later in the webinar. By way of example, though, as I've already touched on, tribunals generally cannot bind third parties. They derive their authority from the arbitration agreement, and the third party is very unlikely to have entered into one. So if the order you seek is against a third party, you're probably better off applying to the courts. A related question is whether the tribunal will grant the relief you seek. Arbitral tribunals can be very reluctant to grant security for costs, for example, and if an order for security is what you seek, you may again be better off applying to courts, assuming, of course, that you can. A very important point is whether there are procedural issues that may be relevant. For example, as I mentioned earlier, arbitral tribunals tend to be extremely reluctant to proceed on applications without notice. If you think that the respondent being given notice of the order that you're seeking may prejudice you, then consider whether an application to court is preferable. And finally, consider whether you can enforce the tribunal's order. Will you need to commence enforcement proceedings in local courts, and if so, will they give effect to the order? Courts can be reluctant to enforce orders, which typically represent interim remedies, as opposed to awards, which are typically final. Arbitral tribunals can be alerted to this, and with the right guidance, should be able to draft a remedy that will be given effect to. However, If you do have to go to court to enforce the tribunal's order, would you have been better off cutting out the middleman, going straight to court in the first place? Your final option is to seek the appointment of an emergency arbitrator, then once that emergency arbitrator is in place, apply to him or her for the order. Again, although this assumes that the appointment of an emergency arbitrator is possible, if your arbitration agreement incorporates the rules of an international arbitral institution, these may well permit this. However, some domestic arbitration rules may not, and if no rules are referenced at all, for example, if you're engaging in an ad hoc arbitration, then appointment of an emergency arbitrator is unlikely to be a possibility. An allied question is, assuming appointment of an emergency arbitrator is possible, whether you're at the right stage of proceedings. If there are no proceedings underway, if the RFA hasn't been filed as yet, then you may well be able to get an emergency arbitrator appointed. If an RFA has been filed, but the tribunal hasn't been constituted, you may need to check the rules quite carefully, as whether or not you can get an emergency arbitrator may depend on why there's no tribunal as yet. Procedural issues are also relevant. In addition to the question of whether or not to give notice, as discussed earlier, you also now have to consider how long it will take to get an emergency arbitrator put in place, and add this to the time he or she will take to consider the application itself. Even the quickest emergency arbitrator procedures will take a day or two, as potential arbitrators consider availability and conflicts. Is this practical, particularly when compared with the option of simply going to court, where judges can be available almost any time on very little notice indeed? And finally, consider whether an order from the emergency arbitrator is enforceable in the jurisdiction you're concerned with. Some local courts may view such orders as being outside the scope of the arbitration agreement and refuse to give effect to them at all. If this happens, the entire emergency arbitrator exercise could have been a waste of time. Applications for interim measures, whether in arbitration or litigation, can superficially be very attractive. However, you should think very carefully about the practicalities before going ahead and making them. Legally, for one thing, the thresholds for obtaining them can be very high. Tribunals may not be able to grant freezing orders, and search orders are only very rarely granted. And even if you do get an order, it may not give you what you actually want. Local courts may not respect an anti-suit injunction, and how much help will a summons witness be to you if he or she really doesn't want to give evidence in the first place? We'll now move on to the second of our topics and look in a little more detail at some of the issues I touched on earlier in the context of whether to go for courts or emergency arbitrators and the matters to consider for both. I look at this question from a common law perspective, considering in particular the laws of England and Wales, and Sadaff will come on to look at it from a civil law perspective. English law, in general, encourages alternative dispute resolution mechanisms with a view to facilitating the resolution of disputes in the manner that the parties themselves see fit, as well, of course, as taking pressures off the courts. As part of this, English law typically enforces arbitration agreements. Touching on the issues I mentioned earlier, English law generally recognises tribunals' rights to grant interim measures, including emergency arbitrators, provided, of course, they're validly appointed in accordance with the arbitration agreement or the governing rules. English courts will enforce such interim measures as are granted, except in certain specified circumstances. With that said, English law doesn't take a completely hands-off approach. The English courts will step in and themselves grant interim measures in disputes, even where there is a valid arbitration agreement. In general, though, they will tend to do so to support the arbitral process. And following on from the above, although the English courts recognise concurrent jurisdiction to a limited extent, and there are a few cases in which a party seeking an interim remedy can apply either to a tribunal or to the courts, I look at these cases in greater detail in the next few slides. In this webinar, I use English law as an internationally recognised and reasonably familiar example of a common law jurisdiction in the context of international arbitration. The principal legislation governing arbitration in England and Wales is the Arbitration Act 1996. This isn't based on UNCITRAL model law, much to, I should say, the dismay of many commentators. I won't speculate on the possible reasons for why it's not so based, but it has been described as being based upon UNCITRAL model law. As just mentioned, English law generally permits arbitral tribunals to grant interim measures. The legal basis for this is section 38 of the Arbitration Act. Subsection 1 of this permits parties to agree on the powers that can be exercised by the tribunals. The English courts will give effect to the agreement that the parties reach, and this will include enforcing the rules of any international arbitral institution that the parties incorporate into their agreement. Most such rules give arbitral tribunals reasonably wide authority to grant such interim measures on a party's application as they see fit, the effect of which tends to be rather wider than the limited range of measures permitted by the Arbitration Act. The remaining provisions I look at on this slide apply in the absence of an agreement as to a tribunal's powers to grant interim measures. Subsection 3 permits a tribunal to order security for costs, although there is an important proviso that security for costs is not to be ordered on the basis that the claimant is outside the jurisdiction. This would usually be a key ground in an application before the English courts, and it's interesting to see that a tribunal cannot rely upon it. Subsection 4 permits a tribunal to direct the inspection, photographing, preservation, custody or detention of property owned or possessed by the respondent, and subsection 6 permits a tribunal to direct the preservation of any evidence in the respondent's custody or control. I should say that section 38 of the Arbitration Act is non-mandatory. It can be excluded by agreement, and as a consequence it will always be important to check for constraints on a tribunal's powers imposed either in the arbitration agreement, which the parties may for any reason have agreed, or in the rules of the International Arbitral Institution incorporated into the agreement, although such constraints would be unlikely in most rules. Note that section 38 applies to arbitration seated in England, Wales and Northern Ireland. The Arbitration Act does not prescribe the powers of tribunals in arbitration seated abroad. Their powers will be determined by the laws of the place where they are seated. The legal basis for courts, as opposed to arbitral tribunals, to grant interim measures in arbitrations is section 44 of the Arbitration Act. Subsection 1 of this provides that the default position, unless the parties agree otherwise, is that the courts can make any order about the matters set out in subsection 2, which I'll come on to, that it could make in court proceedings. This, of course, encompasses an extremely wide range of orders. Subsection 2 identifies the matters about which a court can make an order as being the taking of witness evidence, preservation of evidence, inspection, photographing, preservation, custody or detention of property, and entry of persons onto premises in control of a party to the arbitration for those purposes, sale of goods, and granting of an interim injunction or appointment of a receiver. As you'll see, heads B and C are analogous to subsection 6 and 4 of section 38 of the Act respectively, but the court's powers are wider than the tribunal's. A court order can relate to any evidence or property, not just that in the respondent's ownership, possession or control, and a court can order entry onto premises for enforcement of its order. So subsection 2 establishes that the courts have very wide powers to step in and grant interim measures in support of an application. The rest of section 44 places constraints on these powers, and the courts will defer to the arbitration agreement where appropriate. Subsection 3, for example, makes clear that where the case is one of urgency, the court may make such order on application as it thinks necessary to preserve evidence or assets. Subsection 4 applies where the case is not one of urgency. In this case, the court may act only where an application is on notice, and either the tribunal or all the other parties agree in writing to the application. Clearly here, the courts defer to an arbitration procedure underway and don't unnecessarily seek to assume jurisdiction. Subsection 5 is even wider, but to the same effect. It provides that in any case, the court shall act only if and to the extent that the tribunal or other institution or person given power, clearly a reference to an emergency arbitrator, has no power or is unwilling to act. So the court should step in if the tribunal or emergency arbitrator is prevented by the arbitration agreement from granting the remedy sought. They may also step in where there's a good reason to apply without notice, as just mentioned, but they won't step in just because the tribunal hasn't been appointed, if it is possible to appoint an emergency arbitrator. Finally, section 6 rounds off the deferential provisions and provides that a court can make an order that ceases to have effect on the order of the tribunal competent to act on its subject matter. So once your tribunal is up and running, it can take over on interim measures from the court. Section 44 of the Act is, again, non-mandatory, it can be excluded by agreement, and again, it's important to check for constraints on the court's powers. I should note, however, that case law provides that an agreement granting the tribunal exclusive jurisdiction would in itself not be sufficient to exclude the court's powers under Section 44. Section 44 applies regardless of the seat of the arbitration, but of course English courts are often reluctant to step in and grant interim measures with arbitration seated abroad, particularly where the law of the place of the arbitration is substantially different from English law. Finally, I look at a special circumstance, witnesses. As touched upon earlier, tribunals don't have the power to summon witnesses, and for this reason, English courts may do so without being constrained in the same way as they are on other interim applications under the sections just looked at. An application to summons a witness can only be made with the tribunal's permission or the other party's permission, and the order will only be granted if the witness is located in the UK and the arbitration is seated in England, Wales or Northern Ireland. I'll now hand over to Sadaff to have a look at some issues rising out of civil law jurisdictions.
Thank you, Nadir. As discussed by Nadir, interim measures can be granted by an arbitral tribunal, national court, or an emergency arbitrator. To quickly recap, arbitral tribunals or emergency arbitrators can impose interim measures if the parties agree and or if the institutional rules allow this. The appointment of emergency arbitrators particularly depends on whether the particular institution rules provide for such a process. Similarly, national courts derive the power to grant interim measures through their national laws. When a party is considering who to approach to seek an interim measure, that is, the court or an emergency arbitrator, it is important to consult with your lawyers and understand how interim measures are dealt with at the seat of arbitration. This is because if the national law at the seat gives exclusive jurisdiction to the courts to grant interim measures in an arbitration, a party shouldn't waste precious time considering obtaining an interim measure through an arbitrator or an emergency arbitrator. Now, I'll take you through an example to show you how to obtain an interim measure before commencing arbitration proceedings. Let us assume that you have an arbitration seated in the UAE under the Dubai International Arbitration Centre, that is the DIAC rules. The other party is an offshore company based in a local free zone, and the parent company is a mainland limited liability company, as we see often is the structure in the UAE. You hear industry rumors that the offshore company is in debt and is transferring its assets to the parent company and its sister companies. You are owed 10 million dirhams and are close to starting arbitration proceedings against the offshore company. What do? You could consider obtaining a precautionary attachment order, that is a freezing order, to prevent the respondent from disposing of its assets. You could obtain such an order either through the court or an emergency arbitrator. Now, if you turn to look at the DIAC rules, in their current form, they do not provide for the appointment of emergency arbitrators. However, it is understood that the new draft DIAC rules introduce a procedure for appointing an emergency arbitrator. If you also turn to look at the UAE Federal Arbitration Law that was enacted last year, it doesn't provide for the appointment specifically of emergency arbitrators. In such a situation, a party could seek recourse from the local UAE courts under the UAE Civil Procedure Code and seek a precautionary attachment order. Now, before I turn to look at how this could be done, let's take a brief look at the DIFC LCI rules, because these rules are also commonly used in arbitration agreements in the UAE. The DIFC LCI rules were amended in 2016, and they added a provision on the appointment of emergency arbitrators. Under Article 9.6 of these rules, the LCI court is to determine an application for the appointment of an emergency arbitrator as soon as possible. If the application is granted, an emergency arbitrator shall be appointed by the LCI court within 3 days of the registrar's receipt of the application. So let us assume in our example that instead of Dubai as the seat of arbitration, the seat is the Dubai International Financial Centre, that is the DIFC. Now, the DIFC arbitration law, which is similar to the UAE federal law in that it doesn't specifically refer to emergency arbitrators. However, given the general pro-arbitration approach of the DIFC courts, it is speculated that they may be more inclined to enforce an emergency arbitration award or order. So turning back to our precautionary attachment order that we are now seeking through the UAE court. So precautionary attachment order is an ex parte order, that is, it is issued without the defendant being made aware. And this order can be sought by a party under the UAE Civil Procedure Code. A party seeking a precautionary attachment order should show that it has a credible claim against the defendant and has a legitimate fear that the defendant is dissipating or may dissipate its assets to frustrate any future arbitration award that is issued in favor of the claimant, as would be in the case of our example. A judgment is usually handed down within 24 to 48 hours of an application being made. If a precautionary attachment is granted, the party having obtained the order must commence substantive arbitration proceedings for confirmation of its right within 8 days of obtaining the attachment order. Otherwise, if the defendant challenges the order by filing a grievance with the court will probably revoke the order. I cannot stress enough the importance of this time frame. We have had cases in the past where our client had successfully obtained an attachment order but failed to file the arbitration on time. The respondent then filed a grievance, as expected, against the order, which the court accepted and revoked the attachment order. Our client then went through a 3-year arbitration process, obtained a successful arbitration award, but had difficulty in enforcing the award because by this time the respondent had obviously dissipated its assets. We have sometimes seen a precautionary attachment order can also be an effective tool to bring parties to the table, especially where an attachment order is granted, the party whose assets are successfully attached is keen to settle the claim. A point to note here, so last year, like I mentioned, the UAE enacted its federal arbitration law. Now, this arbitration law, keeping with the spirit of the UAE Civil Procedure Code, does confirm the court's power to issue interim measures, and the court's power to issue ex parte precautionary attachment orders remains. So coming back to our example, now you will recall that the seat of arbitration in our example is Dubai, and the arbitration institution rules to apply were the DIAC rules, which we noted do not provide for the appointment of emergency arbitrators. Let us now assume that the applicable institutional rules are the International Chamber of Commerce rules, that is the ICC rules, and let us have the seat of arbitration still as Dubai. The ICC arbitration rules allow a party to apply for urgent interim measures that cannot wait till an arbitral tribunal is constituted by making an application for such measures under the emergency arbitrator rules. Such applications are accepted by the ICC only if received prior to the file being transferred to the arbitral tribunal. The LCIA arbitration rules contain similar provisions for the appointment of emergency arbitrators. So in our example, the party seeking a precautionary attachment against the debtor's assets could apply under the ICC rules for the appointment of an emergency arbitrator, provided that the parties have not chosen to opt out of the emergency arbitrator provisions. However, a point to note, if the precautionary attachment order is very urgent and it needs to be obtained without notice to the other party, then it would be best to seek such an order through the UAE courts. So, what happens next? Now, once the application is received by the ICC president is to appoint the emergency arbitrator within as short a time as possible, normally within 2 days from the Secretariat's receipt of the application. This time frame is actually longer than those of other institutions. For example, the International Centre for Dispute Resolution, that is the ICDR rules, the Stockholm Chamber of Commerce rules, and even the Australian Centre for International Commercial Arbitration rules all provide for appointment of an emergency arbitrator within 1 business day or even 24 hours. Respondents can resist the appointment of the arbitrator, and they can raise relevant objections within the time limit provided. This time limit obviously varies depending on which institution governs the arbitration agreement. So respondents can challenge the appointment of an emergency arbitrator on the following grounds: jurisdiction of the emergency arbitrator, the emergency arbitrator provision of the relevant rules do not apply, raising an issue with dates in which the emergency arbitrator provisions apply, seeking to rely on the fact it is not a signatory to the arbitration agreement, or pointing out that the parties expressly opted out or modified any relevant provision in the agreement. The respondents could also raise challenges arguing that there is no urgent need for an interim measure to be granted, or that irreparable harm would be suffered if the respondent were to comply with the order. Now, the ICC arbitration rules require that an emergency arbitrator's decision is to take the form of an order. However, the emergency arbitrator's order is not to bind the arbitral tribunal with respect to any question, issue, or dispute determined in the order. Any ICC arbitral tribunal may modify, terminate, or annul the order or any modification made by the emergency arbitrator. Similarly, under the LCIA rules, if these were the institutional rules, for example, applicable in our situation, the emergency arbitrator's decision can take the form of an order or an award, which again may be confirmed, varied, discharged, or revoked in whole or in part by an order or an award made by the arbitral tribunal upon application by any party or on its own initiative. Now, a point to note between the ICC and the LCIA rules. One significant difference in their emergency arbitrator provisions is that under the ICC rules, the emergency arbitrator is to fix and apportion costs, whereas under the LCIA rules, these costs will form part of the arbitration costs. So keeping the above in mind, let us assume that you have obtained an interim order from an emergency arbitrator attaching the offshore company's assets. How do you enforce it against the debtor in the UAE? The nature of emergency arbitrators' decisions may have serious consequences for enforcement of emergency arbitrators' orders in the UAE, especially because these are orders and not awards, at least in the case of ICC arbitrations, and they may be varied by a subsequent arbitral tribunal when it is appointed. With these characteristics, UAE courts may be reluctant to enforce the emergency arbitrator's order on the basis that it is not a final award and it is issued by an emergency arbitrator. Although the UAE federal arbitration law introduces provisions for seeking interim measures and recognizes interim measures issued by arbitrators, which I will discuss in the next section, it makes no mention of emergency arbitrators. Moreover, an emergency arbitrator appointed under the ICC or the LCI rules has the sole task to deal with a party's request for an interim measure and not the merits of the dispute. So it is uncertain as to whether the UAE courts would recognize an order or award issued by an emergency arbitrator. This difficulty with enforcing an emergency arbitrator's order is not unique to the UAE. The enforcement of the emergency arbitrator's order can be problematic in other states as well. This is also because the provisions of the New York Convention may not be applicable in the emergency arbitrator's decision, as it would take the form of an order and not an award. So what recourse then does a party have if a debtor does not comply with the order or award, with the emergency arbitrator's order or award? Where the party against whom the order or award has been issued does not comply with the emergency arbitrator's order, it may be found to have breached the arbitration clause, since the ICC rules provide that the parties undertake to comply with any order made by the emergency arbitrator. But practically speaking, this is of little comfort to a party with the order if the order is not quickly enforced, and if anything, it may forewarn the debtor of the creditor's action. All is not lost. If an emergency arbitrator order is obtained and cannot be enforced, the ICC rules do not prevent a party from seeking an interim measure through the UAE courts. However, again, practically this would mean the party would have to go through the process of obtaining an interim measure through the court. By this time, the other party would have been forewarned and for sure the assets would have gotten rid of. In conclusion, in our scenario where we have the ICC rules apply and the seat of arbitration is the UAE, a party seeking a precautionary attachment would be best served by securing the order directly from the competent UAE court. This will be more effective and avoid unnecessary cost and delay. Also, as the order is issued ex parte, the respondent cannot raise frivolous challenges to the applications. In fact, your lawyers could take this point even further. When drafting your arbitration agreement, they may decide to avoid confusion to expressly opt out of emergency arbitrator provisions where the parties agree to ICC or LCIA institutional rules. So I'll now move on to discussing obtaining relief during the arbitration process. Let us assume, in our example, that we have now obtained a precautionary attachment order against the offshore company, and we filed the arbitration under the DAC rules and the arbitration proceedings are ongoing. During the arbitration, the offshore company, as the respondent, makes an application to the arbitral tribunal for security for costs. This is a type of interim measure. Can a tribunal in the UAE deal with such an application, and what would happen next? Would the result be any different if the arbitration was seated, for example, in London? Before we consider how interim measures can be obtained in a UAE-seated arbitration and a UK-seated arbitration, I will set out some practical tips in preparing for an application for an interim measure. So firstly, and which is obvious, make your application in writing. In the absence of any particular procedural requirements, most applications to the arbitral tribunal for interim measures should be made in writing and copies sent to the other parties to the arbitration. If you are proceeding without notice to the other party may not be copied. This, of course, depends on the circumstances of the case and the relevant rules applicable. Second thing is, you should provide evidence in support of your application. This is something your lawyers should be on top of. For example, if you're seeking conservatory orders in relation to property, you must identify the property and its whereabouts and provide evidence that shows why the relief being requested is necessary. If you are proceeding without notice to the other parties, most tribunals will expect you to explain why. Finally, when drafting the interim application, your lawyers should very clearly state in your application the precise order that you seek. You would think this is obvious, but it sometimes is not. Do not prejudice your chances of success by applying for an order that is too wide in its scope. It is usually best to provide a carefully formulated draft order so that the tribunal can easily see what you're asking for. So you're once again faced with a similar question, that is, do you go to court for your interim measure or do you go to the tribunal? As mentioned previously, when we were considering courts or emergency arbitrators for securing an interim measure before an arbitration, this largely depends on the circumstances of the case, the parties, and the composition and experience of the arbitral tribunal, as well as the seat of arbitration. One situation in which it will often be appropriate to apply to the court is where an order is sought urgently and without notice, as we discussed in the previous section. If applying to the court for an interim measure, a decision will need to be made as to which national court is best placed to act on this effectively. This may be, for example, the court in the country where the relevant assets or evidence is to be found, the court in the country where the defendant is resident or domiciled, the court in the country where the arbitration is seated. So this decision will obviously require preliminary investigations to identify the potentially relevant national courts. As discussed, the national court may not be able to assist and or may not exercise discretion in your favor, so advice should be taken from local lawyers about the practical possibility of obtaining relief from the national court in question. In some jurisdictions, such as the Kingdom of Saudi Arabia, their recently enacted executive regulations of the arbitration law do not expressly authorize an arbitral tribunal to award interim measures. The KSA arbitration law, however, does allow the parties to request precautionary measures prior to the commencement of arbitration through the Court of Appeal. The law also provides for an arbitration tribunal to request the court for an order of interim measures. Under the KSA law, it appears that unless the parties agree to authorize an arbitral tribunal to have the power to order interim or conservatory measures, such measures can only be granted by the court. Therefore, the parties, when drafting the arbitration agreement, where the seat of arbitration is KSA, should carefully consider whether or not they wish to authorize the arbitral tribunal the right to issue interim measures. So let us turn to the UAE story. Now, a key point to note is that an arbitration tribunal should not grant provisional relief unless satisfied that the applicable arbitration law at the seat of arbitration allows the tribunal to do so. You may think this point has been repeated a number of times during the webinar, but we cannot stress enough how important this is. This is important because interim relief ordered by a tribunal will likely not be enforceable in a national court unless the laws governing the arbitration allow such relief. Let us go back to our example of the security for costs application. So to recap, this application has been made to a UAE-seated arbitral tribunal under the DIAC rules. Like most institutional rules, the DIAC rules provide an arbitral tribunal with the discretion to award interim and conservatory measures, subject to any mandatory rules of the applicable law, which of course would be the law of the seat of arbitration. Before the UAE Federal Arbitration Law came into effect, the UAE Civil Procedure Code was silent as to the issue of the tribunal's power to order interim measures, leaving the local courts to decide the issue unless institutional rules chosen by the parties provided otherwise. Now the Federal Arbitration Law expressly provides for tribunals and courts to order interim and conservatory measures in support of arbitral proceedings wherever appropriate. This is definitely a welcome addition. The Federal Arbitration Law provides that a tribunal may order interim or conservatory measures either at the request of a party or on its own motion, and includes a non-exhaustive list of the interim and conservatory measures that a tribunal can order. These include orders to preserve evidence, to preserve goods constituting the subject matter of the dispute, maintain the assets and funds out of which a subsequent award may be satisfied, maintain or restore the status quo, pending final determination, take action that would prevent or refrain from taking action that is likely to cause current or imminent harm or prejudice to the arbitration process itself. The arbitration law also provides that the arbitral tribunal may require a party requesting interim measures to provide adequate security to cover the expenses of such measures and to bear damages resulting from the enforcement of such orders if it later decides that the requesting party was not entitled to such measure. As a point to note, both the DIFC arbitration law and the ADGM regulations in Abu Dhabi contain similar provisions. The purpose is to safeguard the counterparty if the tribunal later finds that in the circumstances the measure should not have been granted. In our current scenario, the respondent has requested for security for costs. A security for costs application is an interim measure filed by the respondent to ensure the claimant is able to pay a potential cost award if the respondent wins the claim. Now, although the UAE Federal Arbitration Law does not contain specific wording, unlike, for example, Article 38(3) of the English Arbitration Act, which clearly provides that the tribunal may order a claimant to provide security for costs of the arbitration, it does provide the tribunal with wide powers to order interim measures. A party seeking an order for security for costs could arguably request for such a measure under the tribunal's broad powers under the DIAC rules, supported now by the provisions of the UAE Federal Arbitration Law. So what factors should the tribunal consider when awarding such a measure? Both the DIAC rules and the UAE Federal Arbitration Law are silent as to what a tribunal should consider when making its decision on an interim measure. Now, depending on how experienced your arbitral tribunal is, the arbitrator should, as a matter of international good practice, weigh the balance of convenience. That is, balance the relief granted to the applicant against the injury caused to the respondent before granting an interim measure. While weighing the balance of convenience, the tribunal must consider whether an award of damages will adequately compensate harm likely to be caused if the interim measure is not granted and if there is a possibility that the requesting party will succeed on the merits of the claim. So in our example, as this is a security for costs application and the DIAC rules are silent, the arbitral tribunal may even give thought to the 2015 guidelines that are issued by the Chartered Institute of Arbitrators in relation to security for costs. And these suggest that the tribunal should take into consideration, 1, the prospects of success of the claims and defenses, 2, the claimant's ability to satisfy a future adverse cost award and the availability of claimant's assets, and 3, whether it is fair in the circumstances to make the order. Unlike the model law, the Federal Arbitration Law does not make a provision for the grant of ex parte interim relief if the counterparty is likely to frustrate the purpose of the interim measure. So the respondent has obtained its security for costs order. What next? Often where an arbitral tribunal issues an interim order during the proceedings, parties comply with the order without further enforcement because they don't want to antagonize the tribunal and they want the tribunal to decide on its claims. In our example, it would be unlikely, and if you have good lawyers, they will probably advise against not complying with a successful security for costs order for this very reason. However, in cases where you do have a recalcitrant party and the party does not comply, it would be seen as a breach of the tribunal's order that the tribunal may look on unfavorably. A party would then need to seek enforcement of the interim measure through the court. If it is a UAE-seated arbitration, as is in our example, this would be through the UAE Federal Arbitration Law, which provides a party to whom interim relief is granted may, after obtaining written permission from the tribunal, request the competent court to enforce the order within 15 days from receipt of the request. So what of seeking an interim measure through the court? As previously discussed, in some cases it is advisable to secure an interim measure through the tribunal simply because the tribunal is familiar with the facts and circumstances of the case. However, in other instances, it may be that an urgent interim measure is required or based on the party's behavior, it may be advisable to go to court. The Federal Arbitration Law gives the court express power to grant interim or conservatory measures, either before or during an arbitration. However, previously there was no concept of interim or injunctive relief available from the courts in the UAE, apart from precautionary attachment of assets, which we already discussed. It will therefore be interesting to see how the courts deal with requests to enforce interim or conservatory measures in aid of arbitrations. The Federal Arbitration Law also allows a tribunal the right to approach the court directly. This is a unique power in the UAE, only available under the Federal Arbitration Law. What I mean by this is, neither the DIFC Arbitration Law nor the ADGM regulations in Abu Dhabi empower a tribunal to directly approach a court to seek interim or conservatory measures in support of arbitral proceedings. Also, the Federal Arbitration Law expressly provides that a party seeking enforcement of a tribunal's orders granting interim measures must be sent to all parties simultaneously. So what if the arbitration was seated in London? Would things be any different? So in this regard, let's look at a case study in an ICC arbitration where we represented the claimant against the government body of Tanzania. The respondent submitted a security for costs application to the arbitral tribunal. The seat of arbitration in this case was London. The respondents in support of the application relied on Article 28(1) of the ICC rules and Article 38(3) of the English Arbitration Act. The respondents argued that the claimant's impecunious behavior is demonstrated by it willfully refusing to comply with the final award that had been issued in another related arbitration. And because of this, the respondents were uncertain as to whether the claimant would comply with an order for costs in the current arbitration if they were not successful. In response, we argued on behalf of the claimant that ICC security for cost orders are rare and usually relate to the impecuniosity of the claimant. In the case, the respondents accepted that the claimant is able to pay costs awarded against it, and therefore there was no impecunious behavior on its part. We also argued that as the ICC rules are primary and Article 38(3) of the English Arbitration Act is not mandatory, it is simply not applicable to the circumstances of this case. Now, Article 28(1) of the ICC rules allows an arbitral tribunal to order conservatory or interim measures, and although the article does not refer expressly to security for costs, it has been the practice for such orders to be made pursuant to this provision. In this case, the arbitral tribunal accepted that it has the power to order security for costs. The arbitral tribunal also accepted our submission on Article 38(3) of the English Arbitration Act. In this regard, the arbitral tribunal reasoned, in any event, in international arbitration, the seat of the arbitration is almost, by definition, unlikely to be the place of residence of either party to the contract. Secondly, as the claimant had argued, the primary provisions governing security for costs are those in the ICC rules. In this case, the respondent was unsuccessful in its security for costs application. So let us briefly look at obtaining interim measures through the UK courts. The UK as a common law jurisdiction is generally considered arbitration friendly. This is evident from its legislation and the power afforded to the courts. Under the English Arbitration Act, under Section 44 of the English Arbitration Act, it states that the court has the same powers in support of arbitration proceedings as it would in court proceedings, that is, to make orders to take and preserve evidence or appointing receivers. Note, only where there is a degree of urgency which requires the court to make such an order. Such powers are not mandatory and may be restricted by the parties. Moreover, the court will only act if the arbitral tribunal cannot act. Notably, English courts use such powers with restraint, rarely making orders against third parties, and particularly not making orders against those outside of the jurisdiction. The English courts are constrained by the Arbitration Act of 1996 from intervening in arbitrations unless the tribunal cannot act, and then only to the extent that is necessary. This could be in situations where the tribunal lacks the power, a tribunal has not been constituted, and it would be too late to appoint an emergency arbitrator, or the relief sought is against a third party who would be outside the tribunal's reach because it is not a party to the arbitration, or where an award of the tribunal would not be effective. I come back to the same point. When drafting your arbitration agreements, give particular importance to the seat of arbitration. As you will have understood from our discussion on interim measures, a lot plays on the manner in which the national courts deal with and treat interim measures. So let us briefly turn our attention to other jurisdictions, such as Singapore, and good old KSA. Interestingly, Singapore has two separate arbitral systems that operate in parallel. International arbitrations are governed by the International Arbitration Act, which gave force of law to the UNCITRAL model law. The other arbitral system is for domestic arbitrations and is governed by their local arbitration act. Unsurprisingly, under the International Arbitration Act in Singapore, national courts are prevented from intervening in an arbitration unless there is an express provision in the law to the contrary. Arbitral tribunals seated in Singapore have wide powers under the Act to grant interim measures of protection sought by an applicant. Unsurprisingly, the law also allows for judicial assistance in granting interim measures to support an arbitration. Now turning to KSA momentarily, in comparison to the jurisdictions just discussed, arbitration in the KSA has not been a popular method of dispute resolution, primarily because of the court's intervention in the arbitral process and the uncertainty surrounding the enforcement of arbitral awards. There have been, however, a couple of recent promising developments. In 2012, the KSA passed a new arbitration law and an enforcement law, and the Saudi Centre for Commercial Arbitration was opened in 2016, complete with publication of its arbitration rules, which are largely based on the UNCITRAL arbitration rules. Under the new KSA law, the KSA arbitration law, the parties can agree that the arbitral tribunal will have the power at the request of one of the parties to order any provisional or precautionary measures of protection as the arbitral tribunal deems fit. The law also contains possible sanctions if a party refuses to comply with the tribunal's order. I'll hand now back to Nadir to take you through enforcement of interim measures with an England and law perspective.
So let's say you've gone ahead and applied for your interim measure and that you've been successful. You've now got in front of you a piece of paper, whether from a court or tribunal, granting the relief that you sought. What now? How do you enforce it? Again, I'll look at this from a common law perspective and the law of England and Wales, and Sadaff will look at it from a civil law perspective. Enforcement of a domestic court order is probably the simplest situation of all. No matter what the jurisdiction, a domestic court order will usually be enforceable immediately without the need for further breaches or applications. The penalty for breach will usually be severe as well. It could constitute contempt of court, leading to potentially significant financial penalties or even imprisonment. Court orders can also bind third parties, as discussed. However, will a court order be time limited? See Section 44, subsection 6 of the Arbitration Act. In England and Wales, for most matters, a court may only be willing to make an order that is valid until the tribunal is competent to, and does, rule on the same matter. Will this require you to relitigate the same application? Enforcement of a foreign court order is tougher. You'll need to look at whether there's a treaty or other enforcement mechanism in place between the country where the judgment was issued and the place where you want to enforce it. A hot topic at present is whether UK court judgments will continue to be enforceable in the EU following Brexit. Assuming there is an enforcement mechanism in place, you'll then need to look at how practically to enforce the order. Will you need to bring a fresh action in the domestic courts of the place where you're seeking to enforce? How long will this take? Is there a chance that domestic courts will reopen the merits and require the application to be relitigated? Might they refuse enforcement on the basis of possibly nebulous public policy issues? Particularly where there is an arbitration agreement in place, the domestic courts in the place where you're seeking to enforce may be of the view that the foreign court that made the order didn't have jurisdiction to do so. This would almost certainly be a defence that the respondent would raise. Even if it didn't ultimately succeed, you'd have to show that you had a clear right to petition the foreign court with your application in the first place. Enforcement of foreign court orders is yet again a whole other webinar. However, the likelihood is that any penalties for breach will kick in only once the foreign court order is enforceable domestically. The delay can often be lengthy, and this may mean, in effect, that your interim remedy loses much of its bite. Enforcement of a tribunal's order will typically require proceedings to be brought in the domestic courts and is subject to many of the same issues as enforcement of a foreign court judgment. In principle, enforcing an order in the same jurisdiction as the seat of the arbitration should be relatively straightforward. However, there are some important matters to bear in mind. As I briefly mentioned earlier, the English courts will not enforce an order, which is a remedy granted on an interim basis, as opposed to an award, which is granted on a final basis. Most arbitral tribunals accustomed to English law will be cognizant of this and will grant carefully drafted interim measures that don't fall afoul of it, but it must be borne in mind, and it's a particular concern for arbitration seated outside England and Wales with arbitrators that may be less familiar with English law. On a similar note, it will also be essential to check whether all procedural requirements in the arbitration have been complied with, as any procedural defects in an order can cause significant hindrance, as you'd expect, to enforceability. As with enforcement of foreign court orders, the likelihood is that any penalties will kick in only once a tribunal's order is given effect to by the courts, and in addition there may be a need for a further breach, as I'll just discuss. In England, a tribunal may make a peremptory order, that's a final order requiring a party to comply with its orders. Section 42 of the Arbitration Act permits a court to enforce a peremptory order on the application of the tribunal, or a party to the proceedings with the tribunal's permission and on notice, or where the parties have agreed the court may do so. This would be the usual route for enforcement of an interim remedy granted by a tribunal, but subsection 3 requires that the court shall not act unless it is satisfied that the applicant has exhausted any available arbitral process, and subsection 4 provides that no order is to be made by the court unless it's satisfied that the respondent has failed to comply with the tribunal's order within the required time, or within reasonable time. It's therefore clear that the Arbitration Act places a few obstacles in the way to enforcement of a tribunal's peremptory order, such that this is to be very much a last resort. The requirement for the tribunal to have made a peremptory order in the first place, which many arbitrators will view as being in itself fairly drastic, the requirement for the applicant to then exhaust all possible arbitral processes, and finally the requirement for the respondent to have further time for compliance. Section 42 of the Arbitration Act, like sections 38 and 44, is non-mandatory. It can be excluded by agreement, so again, it will always be important to check for constraints on the court's powers imposed in the arbitration agreement or in the rules of the arbitral institution incorporated into the agreement, although I should point out that such constraints would be very unlikely in most rules, and I'll come on to this in a second. Again, an agreement granting the tribunal exclusive jurisdiction would in itself not be sufficient to exclude the court's powers under section 42, and there's a long line of case law on this. Section 42, as with section 44, applies, and the English courts can enforce tribunals' peremptory orders regardless of the seat of the arbitration. But of course, the law of the place where the arbitration is seated may not recognise or have an instrument analogous to a peremptory order, and this may, of course, be an obstacle to enforcement. Finally, it should be noted that where the rules of an international arbitral institution contain provisions similar to those under the Arbitration Act that grant a tribunal permission to grant a peremptory order, they've generally been interpreted by the English courts as widening rather than narrowing tribunals' powers for the purposes of section 42, and that can be quite useful. That was a quick run through the English law position on enforcement, and to wrap up, I'll hand over to Sadaff to look at the civil law perspective.
Thank you, Nadir. The granting of interim measures and their consequent enforcement can be as critical as the final arbitral award, because such measures are important to prevent a recalcitrant party from thwarting the arbitration procedure. So I'll give you a couple of recent cases in different civil law jurisdictions, just to show you this, that the trend is that they're following the common law courts. So, for example, in 2016, the Supreme Court of Ukraine appeared willing to consider the enforcement of provisional relief granted by a Stockholm Chamber of Commerce arbitral tribunal in the context of an investor state arbitration. In this case, the relief had been rendered in the form of an award, ordering the state from collecting royalties on gas production from the investor at a higher rate than was previously in place. The investor sought to enforce the emergency award in Ukraine and succeeded at first instance before the Petschersk District Court. Hopefully I got that right. Reportedly because the relief was rendered in the form of an award and thus was enforceable pursuant to the New York Convention. Although this decision was later overturned by the Kiev Court of Appeal in February 2016, the Supreme Court of Ukraine quashed the Court of Appeal's decision, remanding it for reconsideration while holding that a Ukrainian court could only refuse to recognize or enforce an arbitral award on the grounds of Article 5 of the Convention, and that the Kiev Court of Appeal had not taken these grounds into consideration. So if we look at enforcement in Egypt, likewise, in May 2018, the Cairo Court of Appeal became the first Egyptian court to recognize and enforce an arbitral order for interim measures issued by a foreign tribunal, which was seated in Paris in an ICC dispute between a South Korean industrial group and the developer of Damietta port in northern Egypt. The tribunal had issued an interim order ordering one of the parties to cease and desist from Egyptian court proceedings that sought the liquidation of a performance bond. The Court of Appeal held that the arbitral interim measures finally resolved the parties' dispute with respect to the provisional measures sought in the arbitration and were therefore capable of enforcement. Notably, the Cairo Court of Appeal stated that enforcement of interim measure orders issued by arbitral tribunals was consistent with the objectives of the New York Convention, namely to favor the enforcement of arbitration agreements and arbitral awards, to ensure predictability in international commercial dealings and consistency among jurisdictions. So there is a growing trend amongst courts to enforce interim measures issued by an arbitral tribunal. We are to see if this trend is picked up and followed by other civil law countries such as the UAE. The UAE, whose federal arbitration law, like the Egyptian arbitration law, is modeled on the UNCITRAL model law. The arbitration law expressly provides a route to enforce interim measures granted by an arbitral tribunal. The UAE courts have historically been accustomed to just issuing precautionary attachment orders, as we saw during the webinar. So it remains to be seen if, for example, an order to conserve evidence issued by an arbitral tribunal would be enforced by the competent UAE court. Overall, it is promising to see that national courts are willing to step in and enforce interim measures to preserve the status quo in an arbitral dispute, recognizing the importance of such measures as safeguards. As to enforcing the decisions of an arbitrator, they are more inclined to uphold and enforce an interim measure or order made by a fully constituted tribunal. However, ambiguity remains as to whether the decision of an emergency arbitrator would be enforced due to questions relating to the finality of such an award. So, hopefully from this webinar you would have seen that interim measures have an important role to play in international commercial dispute resolution. Because of the inevitable time delay between a dispute coming to a head and the resolution of that dispute by arbitration, as a claimant you face a number of risks. So as a party seeking an interim measure, you should absolutely consider the seat of your arbitration, the urgency of the order, and your lawyers should advise you on the different routes available, and as we have explored in this webinar, and ultimately which route works for you given the circumstances of your case. Thank you.